with this, we come to the close of today's session. We have already seen a few questions in the QA box. We'll attempt to answer all those questions in the QA box, considering the time, which we don't have much now, the constraint which we are facing. We will not be taking up any other questions other than what is in the QA box. If any of you have any questions, please post it in the QA box. We'll be making an attempt to answer all of them right now. So first, I will go to the question which is raised by Mr. Pravesh Kumar. So the question which you are asking is, for which assessment year will this new assessment procedure start becoming applicable? Will all notices should henceforth be covered under this? I think we answered you in the course of our session, sir, that any notice which is issued after 1/4/2021 should be covered only by the new section 148, not under the old section 148. So therefore, the answer is the new section will only apply. So we need not worry about the old law. If the department is insisting on the old law, that is fine. So the second question is from Ayushi Modi. She's asking for examples for income represented in form of it. I will request Bharti. We also thought about it, so Bharti will answer the question.
As my colleague Abhinav had also explained, this expression income represented in the form of an asset has not been ascribed a definition in the Act. This is used in another section, 153A, but that is also a very recent amendment that come out through Finance Act 2017. Therefore, even under that section, we don't have any judicial precedence as on date. But considering the background in which the provision, the expression was used in 153A, what we think is that this expression income represented in the form of an asset should ideally cover only those cases where there has been concealment of income or a bogus expenditure has been booked and claimed as a deduction. Not cases where you have claimed something as a revenue expenditure, department states that is not revenue, that is capital. You have claimed deduction for the particular income, department says, no, the conditions required under the section has not been fulfilled. You are not eligible. You have claimed some exemption. Department again says, no, this exemption you are not entitled to claim, but you have claimed. We think that these kind of cases should not be covered within the ambit of income represented in the form of an asset. So, when we say income represented in the form of an asset, we need to have a clear case where there is some income, either that is sitting in the form of cash or I have converted it to some other form of asset and I have been holding it. The other question can be, as on what date should you be seeing? In our view, this could be any particular date. As long as the department is able to demonstrate that at some point in time, you have been holding this particular income and this has been represented in the form of an asset, that is sufficient. But these kind of regular litigation that we have been facing on other issues of claim of expenditure deduction for various reasons that the conditions or the requirements in the Act have not been fulfilled, those instances should not form within the scope of this expression. And again, the limit, this condition is it's an exceptional situation where you can reassess a person beyond 3 years and up to 10 years. So clearly, this should only apply in those cases where this assessee has concealed income or claimed any deduction which, by giving bogus bills or something of that sort. That is what we think, but we will have to put forth these objections before the department and see how the courts interpret this.
Thank you, Bharti. The next one is on whether this 50 lakhs, which we see as the limit, whether it is applicable for each year or it is cumulative. This section 149, 148, 149, etc. are all dealing with each assessment year. It is not like your block assessment or it is not like your 153, etc., where you go back to 6 years, etc. These are all tests to be applied for each assessment year for each assessee. Therefore, this 50 lakhs is for each assessment year. So we come to the last question, which is a very interesting one. We have one more also. This is with respect to the case study 3, which we were discussing. The question that is posed is in case study 3, if you can see, if we apply the old law, which is 4 years, let us say there is no non-disclosure, there is no concealment. We are talking about assessment year 2015-16, and we apply the old law 4 years. then the time limit would have ended in 31st March 2020. In 31st March 2020 itself, the time limit is over. Then can a law which is made effect from 1/4/2021, can it prospectively extend the time limit for something which has already expired? It's a very good question, but it's a question which the courts have to answer. We will not be in a position to answer. I will rather agree with you that you are right. The law will not be giving life to something which has already expired, but the law has specifically said so. So whether we apply Uttam Steel's decision of the Honorable Supreme Court here, how we are going to overcome it is going to be seen in the days to come. What you are asking here is actually a potential litigation. We appreciate the question, and this is the answer as of now.
Again, under the old law, there is a 6-year time limit also. It is that 6-year
No,
time
I think the question is where 6 years is not applicable in a judgment for a time limit that we are not conceived. Then it becomes very interesting. We come to the last question. What are the steps to be followed in the new assessment procedure? So I think we covered it in one of our slides. What are the steps to be followed? We had very in detail covered the steps which are followed for section 148A. And after 148A, for all this inquiry conducted for which an order is passed, then 148 will come in wherein a notice will be issued. So therefore, it's more like pre-consultation before a 148 notice is issued, or more like codification of DK and drive shaft that we have the 148A procedure. So to put it broadly, 148A procedure, all those steps which we have covered in our slides, those will be the steps, and after which 148 notice will be issued, which will be answered by you and an order passed, and from there you know that if it is not favorable, what all needs to be done. Those are the steps. You can kindly refer to our slides, and that will have the answer. With this, we come to the end of today's session. Thank you very much for participating in good numbers. We are happy that we were able to have the interaction with all of you. Thank you very much for the questions which are posed, which were really very thoughtful and very good. Thank you very much. Manoj, over to you.
I would like to express my appreciation and gratitude to all our distinguished speakers from Lakshmikumaran and Sridharan, who have taken valuable time out of their busy schedules to be here with us today. I'm sure their valuable thoughts, insights, and experiences will enable all of you to understand the impact of this decision. On behalf of LNS, I would like to thank you all. We look forward to seeing you in our upcoming webinars. Due to paucity of time, we could not take all the questions. I request you to write to us and we will try to answer them. Thank you, sir. Thank you, ma'am.